Everyone knew her as America's most beloved talk show host. But when Oprah Winfrey stood up in federal court that day, she was about to reveal a secret she had kept hidden for over 2 decades. Not just media mastery, but deep constitutional law expertise, years of studying First Amendment protections in media law, mastery of press freedom jurisprudence. Judge Amy Coney Barrett was dismissing her as just a television personality seeking publicity, unaware that standing before her was someone who understood media constitutional law better than most Supreme Court clerks. Oprah's first legal argument alone would completely transform Barrett's perception. "Your Honor, Judge Barrett," said Oprah, her voice carrying the same authority that had captivated millions of viewers. "May I speak to you about the Sullivan Standard and its application to modern media defamation law under the First Amendment? What happened that day in the Chicago federal courthouse would revolutionize both media law and public understanding of press freedom." Before diving into this extraordinary legal confrontation, don't forget to like this video and subscribe to our channel for more stories of unexpected constitutional brilliance challenging judicial assumptions. Barrett's World, Conservative Constitutional Authority. Judge Amy Coney Barrett embodied the conservative constitutional establishment. At 52, the former Supreme Court justice had built her reputation on originalist interpretation and textualist analysis of constitutional provisions. A Notre Dame Law School professor, before her judicial appointment, Barrett represented the intellectual rigor of conservative jurisprudence. Her judicial philosophy emphasized strict adherence to constitutional text and original meaning, making her skeptical of expansive interpretations of First Amendment protections that went beyond what she viewed as the framers' original intent. Barrett particularly questioned whether modern media deserved the same constitutional protections as traditional press institutions. That day, her assumptions about Oprah Winfrey were predictable. Yes, Oprah was extraordinarily successful in entertainment. Yes, she wielded enormous cultural influence. But in Barrett's view, she was simply another celebrity using constitutional rhetoric to protect commercial interests rather than a genuine advocate for press freedom. This assessment would prove to be a fundamental miscalculation. Oprah's hidden journey. From media to constitutional scholarship. The world knew Oprah Winfrey as a media pioneer who had transformed television and built a multimedia empire worth billions. From her groundbreaking talk show to her influence on literature, politics, and culture, Oprah's impact on American society was undeniable. Her interviews with presidents, her book club's power to create bestsellers, and her ability to shape public discourse had made her one of the most influential people on earth. But what the public didn't know was that Oprah's media success had sparked a deep intellectual curiosity about the constitutional principles governing press freedom and public discourse. Starting in 2001, concerned about increasing attacks on media credibility and press freedom, Oprah had begun intensive study of First Amendment law and media constitutional rights. With great influence comes great responsibility to understand the legal framework that protects free expression, she'd confided to her longtime friend, Gayle King, during one of their weekend conversations. "If I'm going to be a voice in public discourse, I need to understand the constitutional principles that make that discourse possible." Working with constitutional law professors from Northwestern and University of Chicago, Oprah spent her free time studying Supreme Court precedents, First Amendment theory, and the historical development of press freedom protections. She completed advanced coursework in media law, constitutional interpretation, and the intersection of journalism with democratic governance. By 2023, when the case that would bring her to federal court emerged, Oprah wasn't just defending her media empire's interests. She was also a well-educated advocate for press freedom with genuine expertise in the constitutional law that governed journalism and public discourse. The Case Foundation: Press Freedom versus Public Figure Privacy. The federal case that brought Oprah before Judge Barrett represented one of the most significant media law challenges in decades. Winfrey v. Sullivan Publishing concerned whether public figures could override First Amendment protections by claiming their privacy rights superseded press freedom when media coverage affected their reputation. The case had emerged when Senator Robert Sullivan filed a lawsuit claiming that Oprah's investigative journalism segment about political corruption had violated his privacy rights and damaged his reputation through reckless disregard for truth. Sullivan argued that media personalities like Oprah should be held to higher liability standards than traditional journalists. The implications extended far beyond Oprah's situation. If Sullivan's argument prevailed, it would create a two-tier system of First Amendment protection, where traditional journalists received stronger constitutional protection than other media voices. This could fundamentally reshape press freedom and public discourse in the digital age. For Barrett, this case represented an opportunity to clarify the boundaries of press freedom while protecting individual privacy rights. She viewed it as a matter of balancing constitutional protections with legitimate governmental interests in preventing media abuse. For Oprah, the case was about fundamental constitutional principles, whether the First Amendment protected all forms of journalism equally, and whether public figures could use privacy claims to silence critical media coverage. The setting: Chicago Federal District Court. The stately courtroom of the U.S. District Court for the Northern District of Illinois was packed with media executives, First Amendment scholars, and journalism advocates. This case had drawn national attention both because of Oprah's celebrity status and its potential impact on press freedom. At the defendant's table sat Oprah Winfrey, dressed in a professional navy blazer that projected journalistic seriousness rather than entertainment glamour. Her legal team from the Media Law Resource Center flanked her, though Oprah had insisted on presenting key constitutional arguments herself, a decision that had surprised legal observers. At the plaintiff's table, Senator Sullivan had assembled prominent defamation attorneys, led by media litigation specialist James Morrison, a Harvard Law graduate with decades of experience representing public figures in press freedom cases. Behind them sat political operatives and communication specialists, all confident this would establish important precedents limiting media accountability. Judge Barrett, presiding over this case due to its First Amendment significance, had already expressed skepticism about entertainment personalities' claims to journalistic protection through her previous media law rulings. First contact: the dismissive challenge. Ms. Winfrey, Judge Barrett began, her voice carrying the authority of constitutional scholarship, this court recognizes your commercial success in the entertainment industry. However, First Amendment press protections involve complex constitutional principles and require genuine journalistic purpose rather than mere celebrity commentary. Are you prepared to demonstrate that your media activities deserve constitutional protection traditionally reserved for legitimate journalism? The question was designed to highlight what Barrett saw as the fundamental difference between entertainment personalities and serious journalists. Her tone suggested she expected Oprah to rely on her legal team or demonstrate the kind of constitutional superficiality she associated with celebrity media litigation. Oprah stood deliberately, her posture respectful but confident. Your Honor, I appreciate your concern about the distinction between entertainment and journalism. However, I'd like to address that concern by discussing the Supreme Court's analysis in New York Times versus Sullivan and how the court's protection of press freedom has never been limited to traditional newsroom journalists. A surprised murmur went through the courtroom. This wasn't the celebrity media defense Barrett had expected. The Sullivan standard, Oprah continued, protects uninhibited, robust, and wide-open public debate precisely because the First Amendment recognizes that democratic discourse depends on diverse voices, not just traditional media institutions. Justice Brennan's majority opinion specifically rejected the argument that constitutional protection should be limited to established press entities. Barrett's expression shifted slightly. The response demonstrated actual understanding of constitutional precedent, not just media talking points. Testing the constitutional waters. Ms. Winfrey, Barrett continued, her tone becoming more serious, citing Sullivan is one thing. Understanding how contemporary courts apply the actual malice standard in complex media litigation is quite another. Are you familiar with how modern defamation law balances press freedom against legitimate privacy interests? This was the kind of question designed to separate constitutional amateurs from serious First Amendment scholars. Oprah nodded confidently. Absolutely, Your Honor. The court's post-Sullivan jurisprudence has refined the actual malice standard through cases like Curtis Publishing Co. v. Butts, which extended Sullivan protection to public figures, and Gertz v. Robert Welch, Inc., which established the framework for private figure defamation while maintaining robust protection for public debate. Barrett leaned forward, her interest clearly piqued. Continue with your analysis. The key principle, Oprah proceeded, is that First Amendment protection increases when media coverage addresses matters of public concern, regardless of the speaker's traditional credentials. In Philadelphia newspapers v. Hepps, the court emphasized that the constitutional protection focuses on the content and public importance of the speech, not the institutional status of the speaker. The courtroom had grown quiet. Legal reporters were taking detailed notes, and even Senator Sullivan's attorneys were paying close attention to this unexpected constitutional discourse. The revelation: Oprah's constitutional expertise. Ms. Winfrey, Barrett said, her tone now markedly different from her initial dismissiveness. Your First Amendment analysis demonstrates considerable constitutional sophistication. Where did you develop this expertise in media law and press freedom? Oprah's response would reveal the depth of her constitutional preparation. Your Honor, I've spent over 20 years engaged in intensive study of First Amendment law and media constitutional rights, initially through Northwestern Law's Media and Constitutional Rights program, later through private study with constitutional scholars specializing in press freedom and democratic discourse. I've worked directly with Professor Stephen Calabresi at Northwestern on originalist approaches to First Amendment interpretation, studied under Professor Jeffrey Stone at University of Chicago on press freedom history, and completed advanced coursework through Columbia's Constitutional Law program, focusing specifically on the intersection of media, democracy, and constitutional governance. The courtroom buzzed with surprise. Barrett herself looked genuinely taken aback. Moreover, Oprah continued, my practical experience in media has given me unique insight into how constitutional principles apply to modern journalism and public discourse. I've seen firsthand how press freedom protections enable democratic accountability and how threats to media independence undermine constitutional governance. Barrett's deeper constitutional challenge. Barrett, now taking Oprah's arguments seriously, decided to test the deepest level of her constitutional understanding. Ms. Winfrey, your case essentially argues that entertainment personalities deserve First Amendment protection equivalent to traditional journalists. But how do you address the concern that extending press protections too broadly could undermine the constitutional purpose of protecting democratic discourse? This question went to the heart of modern First Amendment theory, the sophisticated analysis of constitutional purposes that typically separated legal generalists from serious constitutional scholars. Oprah's answer would demonstrate whether she truly understood the complexities of press freedom in democratic governance. Your Honor, that concern reflects a fundamental misunderstanding of First Amendment purposes. The Constitution doesn't protect press freedom to benefit journalists. It protects press freedom to benefit democratic governance and public discourse. She paused to organize her constitutional argument. The Supreme Court's decision in Richmond Newspapers v. Virginia established that First Amendment press protections serve the public's right to receive information, not just the media's right to publish. This principle applies regardless of whether the speaker works for a traditional newspaper or operates through other media platforms. Barrett was now fully engaged with Oprah's constitutional analysis. You're arguing that the First Amendment protects the public's information access rather than institutional journalism. I'm arguing that the First Amendment serves democratic purposes that transcend traditional media categories, Oprah responded. When Senator Sullivan claims that my investigative reporting about political corruption deserves less constitutional protection because I'm not a traditional journalist, he's arguing for a constitutional hierarchy that the First Amendment specifically rejects. The Precedent Analysis, Building Media Constitutional Framework. Moreover, Oprah continued, we have direct precedent for protecting diverse media voices. The Supreme Court's decision in Citizen Publishing Co. v. United States recognized that First Amendment protection serves democratic discourse by preventing concentration of media power in traditional institutions. Barrett was taking careful notes. How does that precedent apply to your specific situation? The constitutional principle applies even more strongly today, Oprah replied. In an era of media consolidation and digital disruption, constitutional protection for diverse voices becomes even more crucial for democratic discourse. My investigative journalism serves the same democratic purposes as traditional reporting, informing the public about government accountability. Oprah then presented her most sophisticated constitutional argument. The court's recent decision in Manhattan Community Access Corp. v. Halleck confirms that First Amendment protection depends on the democratic function of speech, not the institutional status of the speaker. My reporting on Senator Sullivan's corruption serves core First Amendment purposes regardless of my entertainment background. Barrett's constitutional recognition. The change in Judge Barrett was evident to everyone in the courtroom. Her initial skepticism had evolved into genuine engagement with Oprah's constitutional arguments. "Ms. Winfrey," Barrett said, "I must acknowledge that your constitutional analysis has been exceptionally sophisticated. You've presented First Amendment arguments that merit serious consideration from this court." "Thank you, Your Honor," Oprah responded. "I hope this demonstrates that constitutional principles belong to all Americans who participate in democratic discourse. Press freedom isn't the exclusive province of traditional journalism. It's the foundation of democratic communication." Barrett nodded thoughtfully. "Your argument essentially contends that First Amendment press protections should focus on democratic function rather than institutional form. This raises important questions about the scope of constitutional protection in the digital age." The government's response, Senator Sullivan's attorney Morrison, attempted to refocus the constitutional conversation. "Your Honor, while Ms. Winfrey's constitutional studies are noteworthy, the fundamental issue remains accountability. Public figures need protection from media abuse regardless of the speaker's constitutional sophistication." Barrett turned to Morrison with new interest in the constitutional balance. "Counselor, how does your client's position address Ms. Winfrey's argument that First Amendment protection should depend on democratic function rather than speaker credentials?" Morrison found himself defending limitations on press freedom against sophisticated constitutional arguments rather than dismissing celebrity legal theater. "Your Honor, traditional journalism involves professional standards and institutional accountability that entertainment personalities lack." Oprah was prepared for this response. "Your Honor, the First Amendment specifically rejects the argument that constitutional protection should depend on government-approved professional standards. In Miami Herald Publishing Co. v. Tornillo, this court held that the government cannot create constitutional hierarchies based on its assessment of media quality or credentials. Constitutional Framework Development Oprah then presented her proposed constitutional solution. "I suggest a framework that protects democratic discourse while addressing legitimate concerns about media accountability. First, First Amendment protection should apply equally to all speakers addressing matters of public concern. Second, the actual malice standard should apply to all public figure defamation claims regardless of speaker credentials. Third, accountability should come through democratic rather than legal mechanisms, public criticism, market responses, and democratic discourse." Barrett engaged directly with this constitutional framework. "How would your framework address concerns about media irresponsibility?" "The framework protects democratic accountability through constitutional means rather than government censorship," Oprah responded. "When media coverage is inaccurate or unfair, the remedy is more speech, not less protection. The First Amendment trusts democratic discourse to correct media failures better than government regulation." Oprah concluded with her strongest constitutional argument. "Press freedom serves democracy by enabling public accountability of government officials. When public figures like Senator Sullivan can silence critical coverage by claiming privacy rights, they undermine the very democratic accountability that the First Amendment was designed to protect." Barrett's final constitutional assessment. As the hearing concluded, Judge Barrett addressed Oprah directly. Ms. Winfrey, your constitutional arguments today have been remarkable. You've demonstrated understanding of First Amendment law and press freedom that rivals the most experienced media advocates. Thank you, Your Honor. This case has never been about protecting my media empire. It's been about ensuring that First Amendment protections serve their constitutional purpose of enabling democratic discourse, regardless of who participates in that discourse. Barrett reflected on the broader constitutional issues. Your arguments raise fundamental questions about the scope of press freedom in an era of changing media. This court will examine them with the constitutional seriousness they deserve. The landmark press freedom decision 2 weeks later, Judge Barrett issued a comprehensive 41-page decision that would reshape media law and First Amendment jurisprudence. The ruling found that Senator Sullivan's privacy claims violated Oprah's First Amendment rights and established new precedent for protecting diverse voices in democratic discourse. More significantly, Barrett's opinion adopted key elements of Oprah's constitutional framework, creating new standards for how courts would evaluate press freedom claims in the digital age. The decision included an extraordinary judicial acknowledgement. This case demonstrates that constitutional wisdom about press freedom often emerges from those who understand both the power and responsibility of public communication. Ms. Winfrey's analysis has contributed meaningfully to this court's understanding of First Amendment protections for democratic discourse. Broader constitutional and media impact. The Winfrey v. Sullivan decision created immediate changes in media law and sparked national conversation about press freedom and democratic discourse. First Amendment scholars praised the decision as a landmark victory for press freedom in the digital age. Law schools immediately began incorporating Oprah's constitutional arguments into their media law and First Amendment curricula. The case became required reading for constitutional law, media law, and journalism courses nationwide. For the media industry, the decision established crucial precedents protecting diverse voices from government and legal intimidation while preserving the constitutional purposes of press freedom. Personal and cultural transformation. For Oprah Winfrey, the case represented validation of years of constitutional study and commitment to democratic discourse. Legal scholars and press freedom advocates recognized her as a serious constitutional voice rather than simply a media personality defending commercial interests. Judge Barrett later reflected on the case as a reminder about constitutional expertise in the digital age. The Winfrey case taught me that First Amendment wisdom can emerge from practical experience with public communication, and that constitutional protection must evolve to serve democratic purposes in changing media environments. Long-term constitutional legacy. The constitutional precedents established in Winfrey v. Sullivan influenced press freedom law for years afterward. The decision's framework for protecting democratic discourse over institutional journalism became a model for courts addressing media and constitutional law. Most importantly, the case demonstrated that constitutional advocacy could emerge from media experience, and that the most meaningful press freedom arguments often came from those who understood both the power and responsibility of public communication. Oprah Winfrey had proven that true constitutional expertise in the media age requires combining communication experience with rigorous legal scholarship, and that protecting press freedom demands the same constitutional courage that has always been necessary to defend democratic discourse. If you found this incredible story of media constitutional courage and hidden legal brilliance inspiring, please hit that like button and subscribe to our channel for more amazing tales of unexpected expertise challenging judicial assumptions. Ring that notification bell so you never miss these extraordinary stories of how constitutional knowledge and media experience can combine to protect fundamental democratic freedoms. What did you think of Oprah's constitutional expertise? Share your thoughts in the comments below.